Office of Federal Student Aid, we believe that aspiring minds can achieve anything. So we dedicate ourselves to making sure everyone has an opportunity to go to college. Each year, we provide more than $150 billion in grants, loans, and work-study funds, making higher education possible for anyone at any stage of life.
I can go back to college.
I can change careers.
I can make a difference.
Federal Student Aid, proud sponsor of the American Mind. Learn more about money for college at studentaid.gov.
Dwayne, why do you look so serious?
I'm thinking about tonight's PTA meeting.
But our kids are in college. Why are you still going to PTA meetings?
Because the lack of high-performing schools in our community is not just an individual issue, it's a community issue. As African Americans, we should all be concerned.
Well, what are we going to do about it?
Everything we can. Education for our youth is in a state of emergency. Our kids need a village of people like you and me to fight for the right to a quality education.
Ah, got it. I've been so focused on my own kids. But they're all our kids. Thanks for the wake-up call that it still takes a village. How can I get involved?
Ask questions. Be a part of the solution. Take action and get involved to ensure that high-performing schools are in your community. Start or join a neighborhood coalition for high-performing schools. This message is brought to you by 100 Black Men of America Incorporated in partnership with SCLC, U.S. Black Chambers Incorporated, Delta Research and Educational Foundation, and Jack and Jill of America Foundation.
The opinions expressed on the following sponsored program are strictly those of the host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. Welcome to the Ask the Experts show with local experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Hey, good afternoon. You have another Ask the Experts. I was just telling our expert, because this is the first Thursday of the month, how easy this show is. And we're missing someone today. I want to say hello, first of all, to one of our guests, Robert K. This is the K. Bender Rimbaum Law Firm, Community Association Lawyers. That means it's time to start making your phone calls. Good morning. Oh, good afternoon.
Oh, good morning and good afternoon.
Yeah, I started very early this morning. Hey, the phone number here is 888-565-1470. We will be taking your calls throughout the show. You can also listen to us on 95.3 FM or 1470 AM. We normally have one of your partners with us, Michael Bender. He's not here today. He's teaching today.
He's just finished up a course at the expo that was in Broward County. There was an expo on Tuesday in Palm Beach County. There's an expo today in Broward County. Next Tuesday, there's another expo down in Miami.
You guys are going to be busy.
We are busy.
We do something at the beginning of the show because we always have new listeners tuning in. This is not what you normally do. This is usually something Michael does, but tell us about.
We share.
This is your company. This is your firm.
Well, I started it.
Tell us about your firm.
Well, K. Bender Rimbaum is a full-service law firm that works in the area of community association law. We represent condominiums, homeowner association, cooperatives, and we provide them with all of their legal needs, be it from the day-to-day operations, legal issues that come up as they're dealing with everything that they deal with. We have clients that run as low as maybe 5 units to several thousand units. So their needs could vary, but the legal principles are much the same. So dealing with interpretations of their governing documents, dealing with enforcement issues, collection of unpaid assessments, negotiating and drafting contracts with third-party vendors, enforcing on the contracts if there's a contract dispute, pursuing developer claims, construction defects, pretty much soup to nuts, everything that a community association deals with on a day-to-day basis.
And if you're thinking about running for the board, this is a great show to listen to.
One of the best.
Yes. And I'm going to say this because he doesn't ever do it. K. Bender Rimbaum is actually one of the largest firms in Florida. So these guys are
not in Florida.
You're kidding.
Perhaps in the area that we practice in, but not in
No.
general.
I did listen. I meant in your area of practice. Not.
Oh, okay.
I apologize. Sometimes you just think that people know what you're talking about. Okay, so one of the biggest community association law firms in Florida.
We have offices in Pompano Beach and Palm Beach Gardens at the present time. And so we are available at 1-800-974-0680 or on our website is kbrlegal.com.
Which you've got to go see.
Must.
There's not another website with so much great information as yours. So phone lines are open. Give us a call here at 888-565-1470. You know, we do a little Twitter, a little Facebook about our shows, and you always get the most response. So we've actually started bringing some of the questions. If you don't mind, can we start there?
Sure.
Okay. This is from Catherine in Coconut Creek. Is there a proper way of making amendments to the governing documents for HOA?
Well, Catherine, we appreciate you listening and sending in your question. There definitely is a proper way. The governing documents themselves each will provide within them a procedure for their own amendment. The Declaration of Covenants, the Articles of Incorporation, the bylaws, they're each separate documents, and they should each have a provision that tells you what percentage of the owners are necessary to vote in order to adopt the amendment. The statute does provide if there is no provision in the governing documents for amendment, then it could be by a supermajority of 2/3. So that's an option if your documents do not provide for what is necessary. But you got to look at your documents to see that first. It would be helpful, of course, if the association has an attorney to check with the attorney and get verification before you jump into making amendments. Homeowners associations did not have in the statute, like condominiums do, a format. For many, many years, condominiums have had in the statute a specific format for presentation of amendments where you have to present all the language that's currently in existence and what's specifically being changed, with striking through what's going out, underlining what's coming in. And HOAs did not have that for a very, very long time, but we recommend that their boards do follow that process and record amendments in that fashion.
I think if a person listens to the show for the hour here and they do not have representation, you're going to see why you should, because you really shouldn't try to handle this yourself. There's so many different aspects to being a board member, running a complex.
Well, yes, you have your governing documents in place that contain the restrictions and the corporate procedures. You also have the statutes that are being changed on an annual basis, and you have decisions in the courts that are happening quite regularly. So things are always moving, always changing, and if you fall behind, that could create some liability for your association.
So we're going to probably, because we do get a lot of calls during the show, we'll probably be sprinkling in calls with a lot of these questions. Plus, you're going to be telling people you have a lot of things coming up in the month of October.
October's a busy month for classes, particularly next week. Next Wednesday, actually, we have two different legal updates being presented. One at the Galuppi's restaurant on Federal Highway in Pompano Beach. Check-ins at 7:30 a.m. with the class beginning at 8:15 a.m. for 2 hours. Lisa McGill will be presenting at that particular venue. And then at 11 o'clock in Plantation, at the Plantation Preserve Golf Course and Club, Michael Bender will be presenting, and both of these will be the 2019 legal update, which is basically all the changes in the legislation that happened in 2018.
Okay. Let's go to our first call.
Okay.
We have Sarah. Hi, Sarah.
Hello. Very upset, so I'm a little nervous here.
That's okay.
Nothing to be nervous
We're friends.
about.
A petitioner in a HOA arbitration with several other people in the HOA, and I found in one of the responses from the HOA board, they libeled me, and it's libel per se. I have a background in media and law, and putting court cases on TV and for PBS and BBC and stuff like that, and studied it. And it's directly libel per se. They said I committed a crime, like a third-degree felony, let's say burglary. And they sent it in to the arbitrator. And I know that attorneys are not supposed to lie to the state or to the court. And this is an out-and-out lie. It was checked out by a couple of cops. I did nothing. I talked to a cop. Nothing was ever filed. I was never arrested, never charged. What do I do? I called the state arbitration office, and I know in this arbitration that we were told you're not supposed to contact the arbitrator. And I did not get into this arbitration voluntarily. Other people put my name in, and I told them no, because I don't know what your case is, and I don't know who your attorney is, but they put my name in anyway. And I actually wanted to use you all because the attorney that they chose, I had no background on him, and he's, does many things. He writes wills, he does real estate, da-da-da-da-da-da. And I thought if anybody's going to handle it, you are the experts. I'm very concerned about this because it can follow me. And it could be used against me in the HOA. Look, and somebody could point out, oh, look in this legal document, see, she burglarized this house. And we have video. Or say I move and somebody wants to check my references, and that comes up. And besides, the not emotionally very happy with this. So how should I proceed?
Well, you mentioned there is an attorney that's representing you as part of a group?
Yes, and I wrote him and I told him that attorneys are not supposed to lie, that he should report it, and to get back to me and what he's doing about it, because attorneys are supposed to report other attorneys that lie. I know that, and I did contact the bar, and I got the form to make a complaint about the attorney who wrote this up, and that's as far as I've gone.
Well, when there's pending litigation or arbitration, as you've indicated, the bar prefers not to be dealing with complaints, so you'd be better off waiting for the matter to be completed to address it with the bar.
Okay.
There is, in pleadings, which this would be considered, a qualified privilege on the attorney to make certain statements if done in good faith and believing it to be accurate and true. Obviously, an attorney cannot knowingly lie and put false statements into a document, and whether or not the attorney knew or didn't know will be an issue for determination. But there is this qualified privilege to put things into these documents that might otherwise be actionable, as you indicate, libel per se.
It was not good faith. It was done with malice.
Well, you think so, but you don't know for sure unless you have a way to corroborate that and prove the malice. Now, I appreciate your perspective on it, but your option would be to engage an attorney that works in the field of pursuing these types of claims and follow up that way. Typically, they will work on a contingency, so that is an option that you might be able to consider.
Yeah, it was knowingly done because I did provide an affidavit and knowledge that I had. So I provided, and so what they're trying to do is basically besmirch my reputation and my word and my good faith, etc. Okay, and
think we must have lost her. Okay. Well, let's go to
break time.
Yeah, let's go to break. We come back. Mary, you are first up.
Could your community association benefit from having a more hands-on, education-centered insurance agent? For over 30 years, SCAR Insurance Group has worked with hundreds of community associations throughout Florida, putting education first. Let's face it, insurance can be very complicated and complex. It really pays for itself to partner with the right insurance agency and not just get a quote. Family owned and operated, every employee at SCAR Insurance takes pride in creating an exceptional, warm, family-like experience for every client, every time. SCAR Insurance Group specializes in community association insurance, but can also assist you with home, auto, business, and life insurance. Aren't you tired of not getting all the facts up front from your insurance agent? Contact us today for a free, no-obligation analysis of your current insurance program. Call now at 800-299-5055. Again, 800-299-5055. Or visit us at www.scarrinsurance.com.
And we are back. Let's go right to the phones. We got a board full of calls. Let's go to Mary. Hi, Mary.
Hi. Thank you for taking my call. I have two real quick questions.
That's fine. That's fine.
Okay. One of them, the president on my board has been president for 20 years, and I heard there's a new law that says that you can't be a board member if you've been a board member for over 8 years. Unless there's nobody else running. But
Mary, it's a condominium?
Pardon me? Yeah, in a condo. Mm-hmm. Does this rule apply like right away, or do you have to wait another 8 years? So he'll be president for 28 years before we can get rid of him.
Well, it could even be longer if you don't have enough other people that are involved. But there is a statutory provision. It was first adopted last year in the statute, but it provided if there were terms of 2 years, that then the term limit would be 4 terms or 8 years, and that did not apply to any board member that had 1 year term.
Yeah, which we do.
And at the time, all the practitioners concluded that it was not a retroactive application since it was a new statute, but rather starting July 1 of 2017 going forward. Well, in the latest legislative session, they changed that to provide for the 8-year term limit that you've identified. But now practitioners around the state are divided as to whether they believe it to be retroactive in its application or only starting July 1 of this year going forward. Our personal opinion is that it is not retroactive, that the clock starts this year, and that board member could go 8 more years or longer if there's not enough candidates or if 2/3 of the owners vote to allow it.
Okay, so you're saying that he can serve another 8 more years. I was hoping we were going to get rid of him.
Well, it's my understanding the Division of Condominium has expressed the opinion that it started this year and it's retroactive. So they don't really have the authority to make that determination. That's beyond their jurisdiction. We really need a determination by a court, and that's going to take some time to work its way through the system if anyone ever makes such a challenge.
Okay. The other question I have is, my board meetings are usually the end of December, and I just got a notice that I have a board meeting November 28th. Is that legal to change the board meeting if the docs say it's a certain date and they change it to a month earlier?
When you're saying board meeting, you mean your annual meeting?
My annual meeting, yeah.
That's when the election takes place?
Pardon me?
That you're talking about when the election will take place?
Yes, the election and the budget meeting.
Okay. Generally speaking, the board should be following what's in the bylaws. And there has been some recent court decisions that don't allow the board to make such changes, but in order to pursue that, you would have to file legal action. A couple of days difference is a type of violation that typically does not have any damages that can be put to it, unless perhaps you scheduled yourself to be in South Florida for the specific event and then they changed it on you. There's some monetary damage you could claim. The Division of Condominium does not have jurisdiction over that issue because it's a corporate function, so that would take it to the courts.
Okay, corporate. Okay. Thank you so much. Really appreciate the information.
Thank you,
Thanks, Mary. Hey, let's go to Edward. Hi, Edward.
Yes. Thank you for taking my call. I am a member of a HOA, and this community is a planned unit development, and every lot in the community is exactly the same size. A member of the board just put up a new fence around their property, and they have gone out into the common area by about at least 20 feet on each side. And what do you suggest?
Has the board approved that taking
It was done without any approval.
Done without any approval? Well, the first thing to do is you could send correspondence to the board or management, however your community is operated, and ask for an official position as to the placement of that fence. Is a fence approval something that is typically done by the board for if somebody were to put something up?
No, because of MRTA, the bylaws are not effective at this moment. They have been sent to the state for approval, and we're waiting for approval to come back.
Okay, but during the time that your covenants were in effect and before the expiration, was the approval for fences something that was a routine thing, or is that something the board never did?
Yes, that is fact.
Okay, well then certainly make that inquiry. If the board ignores you or doesn't give you a satisfactory response, then you may need to bring in an attorney to rattle the cages a little bit further about the improper expansion of the property of a board member.
Am I responsible to go and get an independent attorney, or can we use the association attorneys?
Well, the association attorney has to pursue whatever the board of directors instructs the attorney to do. So he or she likely would not be responsive to you in making that inquiry other than responding on behalf of the board. So if you want to pursue it from the perspective of a representative of all the affected homeowners who's had their common properties taken, or at least appropriated in this fashion, an independent attorney would likely be needed.
The board is non-functional. It is non-communicative, and it does absolutely nothing.
Is there interested homeowners looking to possibly replace them?
Oh, of course, yes.
So there's the possibility of recall, or at the whenever the annual election is, to have a new group of people come in.
Yes, of course. But would like to address this infringement on the common area.
Well, I'd start off with a written inquiry by certified mail is your best approach, and see where you get from there. And if you don't get a satisfactory response, then it may require a little bit bigger stick.
Well, like all or most HOAs, people do not want to spend money, their own private money, on association actions, which causes a problem.
Yes. Well, that tends to tie your hands unless you're
Yeah.
willing to bear all the cost yourself, which don't know why you'd want to do that.
Right. Is there a chance to get reimbursed in any type of legal action?
There is a chance. If there's litigation and you prevail, there should be recovery of attorney's fees. But bear in mind, you're bringing action against the community, which is made up of all the homeowners, and all the money they have comes from everybody else. So,
And including myself.
including yourself, although you would be accepted from any assessment that would be required to pay such a judgment. There may be the possibility of insurance coming in to defend, which might offer another source of recovery.
Okay. Thank you.
Thanks,
Thank you very
Edward.
much.
We have to go to a break. We come back, we've got Pam online.
Hang in there, Pam.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680. You are listening to the Ask the Experts show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 5 to 6 p.m. Now, get ready for more Ask the Experts.
We are back. This is the first Thursday of the month, so that means we have the law firm of K. Bender Rembaum. Their community association lawyers have been with us forever, and we're going to go, well, let's take a phone call from Pam, and then we got to talk about all the things you've got coming up this month.
Okay.
Hi, Pam.
Hi, how are you?
Good. You have a question?
I do. I am a unit owner in a condo association, and we currently have a type of wood shank, if you will, type of mansards, and the board is looking to replace them with more of your shingle type material. Is this not considered a material alteration, and we should vote on that?
Well, yes, it is a material alteration, and whether or not you have to vote on it will depend on language within your declaration of condominium. The statute says... I'm sorry?
I'm sorry. It does. Our declaration does say any material alteration should be voted on 2/3 of the owners.
Okay, with that provision in your declaration, that would require a vote of the owners on this change. Now, there is one caveat or exception, and if the board can conclusively show that the change is necessary maintenance, that the original product is no longer available, or it deteriorates too quickly and is not something that should be considered for future use, and is more of a maintenance change than a cosmetic change, that's an exception to the requirement of owner approval. And that's a factual issue that would have to be the determination of an arbitrator or court of law if it came to that, if the owners disagreed with the determination of the board to just go ahead and do that. The best thing for the board to do is present it to the owners for a vote.
Yeah, and like everything else, it's not. So,
well, what you can do is contact the Division of Condominium and file a complaint that the board is making alterations without owner approval, and they'll pursue that.
Okay. I sure will. Thank you very much.
Thanks, Pam. So you got a pretty busy month this month.
It's a busy month. I mentioned the two legal updates that are being presented next week, one at the Galuppi's Restaurant, both on October the 10th. The Galuppi's Restaurant on Federal Highway in Pompano Beach is Wednesday morning. Check-in at 7:30. The class starts at 8:30 a.m. It's a morning class.
You got a lot of new places now.
Yeah, well, Galuppi's is one that we visit pretty regular, but the other is in the late morning, 11 a.m. at the Plantation Preserve Golf Course and Club on Broward Boulevard in Plantation. 11 a.m. to 1:30, Michael Bender will be presenting a legal update. Both of those presentations do have continuing education credits for managers. We also have a pretty busy schedule of classes in both the Pompano Beach and Palm Beach Gardens offices in October. Also on October 10th, next Wednesday, in Palm Beach Gardens, we have the Homeowner Association Board Member Certification course starting at 6 p.m. And then on October 17th in Palm Beach Gardens, we have the Condominium Association Board Member Certification course, also 6 p.m. And on October 24th in Palm Beach Gardens, the 2019 legal update. Those all start at 6 o'clock, run till 8:30. Space is limited, so it's important to RSVP. You can do so by email to Tricia, TRISHA, at kbrlegal.com, or call 561-241-4462 or 800-974-0680. In Pompano Beach, on October the 16th, we have Jumping into the Present. Why updating governing documents to your association is critically important. That's a 6:30 one-hour course. Then on October 23rd, guest restrictions and screening tenants and new owners. Is it worthwhile? Also a one-hour course at 6:30, Tuesday, October 23rd. To RSVP for either of those, you can write to seminars@kbrlegal.com. or call the Pompano office 954-928-0680 or 800-974-0680. Then next month, November the 5th, we'll kick off the annual Ask the Attorneys Wednesday, November 7th in Tamarack at the Tamarack Community Center from 6:30 to 8:30. You know what the
That's my
Ask
favorite.
the Attorneys, you like that.
I love Ask the Attorneys.
Michael and I will be there, and it's a town hall type setting with open questions from the floor. And as I also mentioned, there is another expo next week on Tuesday at the James L. Knight Center. There will be a legal update, the 2019 legal update in the afternoon at the expo at the James L. Knight Center Tuesday.
Busy.
Yeah, we have a lot going on this month.
And your seminars are free.
Seminars are free.
So no excuse. Get out there. And that, I got to tell you.
But if you RSVP, please do come, or if you can't come, let us know, because there are people that once we fill up, we'd like to be able to accommodate everybody. And if you can't come, let us know.
And you do a little notch there, too.
We do.
So
we have a light snack that we provide, yes.
But I think that's really cool how you give back. You don't just take. You do a lot of seminars, all free. And I think it's wonderful.
Now, if you go to the website at kbrlegal.com, there is a listing of all of our upcoming events. So anything that you are interested in that you maybe didn't write down here, you're driving in your car, you can go to the website, kbrlegal.com, and the calendar will show everything that you might want to know about upcoming events.
Hey, if you'd like to call here, we've got an open line. 888-565-1470, 888-565-1470. We have an open line now. So we've been taking, it's starting to get kind of crazy. We got 15 questions in the last 2 weeks.
We won't get to all of them, sorry.
No, we won't, but, I don't know which ones are good, so I'm just going to go right down the road. The first one, or second one, is from Jake in Fort Lauderdale, does an HOA have the power by the board to require every homeowner to have their lights on from dusk to dawn?
Well,
I've never even heard of that.
That's an interesting requirement. It makes sense, certainly, for security purposes. It would require a review of the governing documents, the Declaration of Covenants, to see if there is sufficient authority there for such a requirement. I would be expecting there would need to be, because to have a rule of that nature just by itself, that seems to go beyond the scope of what the Declaration requires. So that one is in the gray area.
Okay.
I don't want to say yes or no, but the documents do need to be reviewed in order to say for sure.
Sounds like they've asked them to keep their lights on at night, throughout the night.
It adds to your expense, of course, as a homeowner, but it also adds to the security of the community that there be lights. Now, if there were common lights all around, that would be better, but that would also add to your costs because the association would be paying. So one way or the other, it's going to cost to do it.
Let's go to the phones. We've got Norm.
Hello, Norm.
Hey, how you doing? How's everyone?
Good. Good. How about you?
Good, thank you. I have one question particularly. Is it ever appropriate for a board members, the management, and all vendors to sign an agreement that no one is accepting gifts more than $25?
Well, you said a homeowner association?
Yes.
Well, it's certainly appropriate, but it isn't necessary. There shouldn't be gifts of that nature that are being given or offered, and certainly board members should not be taking personal gains from vendors or.
Of course not. Yes, but if everyone is on the same playing field, let's say all vendors have to sign an agreement, the management company and the board members, wouldn't that equalize it so that everyone is sort of aware of it?
It certainly would be helpful, but the other issue is, what if they sign it and then do it anyway? Who's going to enforce that?
Well, that's a good point. I mean, let's say it ever came to light, then wouldn't that be...
well, it's political, certainly, and you could use that to get rid of a board member that has been acting contrary to the agreement that they signed.
Right.
As to the vendors,
right? Or a vendor.
With the vendors, the board chooses them, so the politics there is, again, as to the board, not to the vendors, and the enforceability side of it to the vendors is very iffy.
Right, okay. And then the management company, of course, would fall into that as well, right?
Yes. Well, the managers may have a licensing issue if they're accepting gifts of more than that amount.
Right. So are you saying that it's not enforceable or not useful?
Well, the question is who's it between, and who's the party that's damaged if it's violated, and how is it going to be enforced?
Right. Good points. Right. So it might create more problems than it's worth.
It could. Now, it's be fine for the board to adopt a policy of that nature without requiring an agreement and have that in place, that's going to be a requirement, and it's purely political in that aspect.
Yeah, exactly.
But in an open community, that's things that come to light.
Yes, okay, that's clear. The other question I have for you is the budget, operating funds. When everything else is paid, what do you have left are operating funds? Like what is, if you have X dollars after all the bills are paid, right?
Yes.
What line item does that become?
So in essence, you're saying you have more money than you need to operate for the year?
Yes, or for the month, each month, let's say.
Each month?
Month. So, yeah, like over a period of time.
Well, monthly, it's fluid, so you wouldn't be looking at the month as much as on an annual basis, because it's supposed to be an annual budget. any
Right.
monies that's left over is considered surplus and is technically to be used to offset future assessments. So it might be a reduction into the following year needs, and you
Okay.
just call that surplus.
Okay, or do extra work in the community, right? You know,
Well,
extra work,
if you have extra money and there are things that need to be done, certainly you can do that.
right. Right now, thank you for that. Operating funds means what? I just want to get clear. The operating funds, you get money in every month, and that goes to run the business, so to speak, of the community.
Yes.
Okay. All right. You answered both my questions.
All right. Thanks for calling. Thanks for listening.
Thanks, Norm.
Okay, you're welcome. Thank you for doing it.
My pleasure.
You know, you should, as a homeowner, condo owner, you should have your board members listen to the show. Because, we have one of the finest law firms for community association law, and sometimes maybe they might not know that. What's the phone number at the office?
You can reach us at 800-974-0680. If you want to call the Pompano Beach office, 954-928-0680. Palm Beach Gardens at 561-241-4462.
Okay. So, this Jake, who had his question, had actually two questions. His second one was, do rules and regulations need to be recorded now?
Well, Jake, that is also a good question. And certainly, under changes that have recently been made to the Homeowner Association Statute, Chapter 720, the governing document, by definition, has been expanded to include rules and regulations. And the statute requires that all the governing documents be recorded, which has been interpreted to mean that rules and regulations, if they're adopted, should be recorded as well. You need to review your own governing documents as to rules and regulations, how they're adopted. Sometimes there's a procedure that requires a mailing to the owners with at least 30 days before it's effective. So when there's little quirks like that, you want to be sure that you're complying with all of those requirements before you go ahead and record them. And certainly if they were recorded in the past, any changes you make to them would also need to be recorded.
Okay.
And Michael Bender, I understand, is listening. So hello to Michael
Hi,
Bender.
Michael. Let's go to our final break, and when we come back, we can even take a phone call. Phone number here is 888-565-1470. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
Hey, we are back. We're here for our final 15 minutes. If you have a question, you can give us a call here. This is Robert K. He's one of the senior partners with K. Bender Rembaum, Community Association Lawyers. Phone number here is 888-565-1470. I know some people called before, and I guess they got tired of holding. So we have an open line now if you'd like to call in at 888-565-1470. I got a couple more questions here that people wrote in.
I heard you do.
Now, this is Maisie, Coral Springs. So she's a very smart lady. I live in Coral Springs.
Maybe she's your neighbor.
Yeah. Who insures unit owner improvements to limited common element areas?
Again, this is a documentary specific type question. If it's a unit owner improvement, typically the unit owner is responsible to ensure and to maintain it. Limited common elements, quite often, while they are common elements and they are exclusively used by a particular unit owner, that's why they are limited common elements by definition. Documents quite often require associations to maintain some of it, but sometimes owners have to maintain it. So, an example, parking space in a garage. That's not something you'd expect a unit owner to be maintaining because it's in a garage. So more often than not, it's an association requirement. You're not going to make many alterations to that. So you're probably talking more like a balcony or patio as a limited common element. And so you could enclose it or whatever you do with there, put things in there. So in that instance, more often it's going to be a unit owner responsibility. Under condominium law, the individual is required to provide insurance on a list of items, which are the wall, floor, and ceiling coverings, the personal property within the unit. So this would fall under that type of a category, absent anything more specific in the documents.
Mark in Highland Beach. You know where Highland Beach is?
I do.
I do too. I used to live there.
It's right around the corner.
Can the association limit the number of occupants in my home?
Again, a document-specific question. It is possibly, yes, the association could have limits on the number of occupants within a unit if that is specifically set forth in the governing documents and is clearly indicated. Quite often you'll see, based on the number of individuals per bedroom, a 3-bedroom might have 6, a 2-bedroom might have 4. But a caveat to that is that if the restriction should have what's called a disparate effect on families with children under the age of 18 years, such a occupancy limitation can be found to be discriminatory under fair housing laws. And in some counties, such as Broward County, children under 10 are considered a half a person. So you have to know in your county whether there's a quirk of that nature. And so while you think they're exceeding the occupancy limit, they're really not, because the children aren't a full person. So
is that just in Broward County? It's not Palm Beach? Or
I don't believe Palm Beach has it, but I know Broward does.
Okay. This is from Laura in Deerfield. She said, I've tried to call several times, but I've got tired of waiting.
Oh, Laura.
Yes. Got tired of holding. Last year determined board terms were not retroactive, but I heard...
Well, that was the question we took earlier.
Is that what it was?
Yeah.
Okay, about the new laws.
So Laura got
I just
your
want to
answer.
make sure she knows.
It's up in the air. Our opinion is that it's not retroactive. Others believe that it is retroactive, and it's going to take a court to give us a final answer.
And here's a question, just so I can say, William, we asked your question. I think one of our callers, this is for an HOA. We were having problems getting a quorum for board members who have been around for a long time. We had a caller about that.
Mm-hmm.
How do we change the board members, I guess, if we can't get a quorum?
Well, quite often we see apathy in communities where individuals aren't willing to serve on the boards, and they get some people in there, and while they're willing to put themselves on the board, they're not necessarily willing to participate, so they don't come to board meetings, or their business schedules or their personal lives take them away. Yeah, we do see that. Right. And they can't get enough people to attend board meetings to be a quorum so they can conduct business. That becomes a problem. And removing them becomes a problem as well if they won't resign. The statute makes it difficult to remove a board member. You typically have to go through a recall process or wait till your annual election and deal with it that way. Sometimes documents provide that if a board member misses so many meetings consecutively without excuse, that is considered a resignation, and then that person is off the board. Another opportunity is monitor that individual's assessment account. If they become delinquent for more than 90 days, they're automatically off the board. So that's another manner of creating a vacancy, but you still need participating board members. If the board members are not participating and involved, then you need to go through the recall process to remove them. Alternatively, if there's an annual election, you need enough people that are willing to participate to run.
Why would someone become a board member?
Well, sometimes they just get appointed because they can't get a quorum to even have an election.
Okay. So I want you to tell everybody, because, again, we still get new people every month tuning into the show. Tell me what the difference is in your firm and other firms that do association law.
Well, I can't necessarily tell you about others, but I can tell you about ourselves. And what we do is we are client friendly, as it were.
Service-oriented.
Service-oriented. We have live receptionists. We have attorneys who are responsive to the inquiries that are made to them quickly and efficiently and cost-effectively. We respond to the inquiries within the same day if possible, or within a day if things get beyond, but depending on when they come in. And the responses that our clients receive are tailored and prepared in a way that would be generally understandable by the layperson without having to get an attorney to translate what it was that the advice was given. So consumer-friendly, client-friendly, service orientation, and cost-effective are the issues that we strive for all of our clients.
And I remember a couple of years ago, we had someone call that actually called the firm that was representing him, and she said it took them 4 days to get back to them.
Well, we hear all sorts of horror stories, and it's amazing that people stick with attorneys that aren't responsive to them.
Right. So, and I know because I've been to your office, you have plenty of support people. Give everybody your phone number.
Well, they can reach us at 800-974-0680.
And your website, which is incredible. It's got so much great educational information.
Well, we have on the resource tab, we have legal morsels, which are topical articles we write periodically. We also have Rambaum's Association Roundup, which Mr. Rambaum prepares himself, and he's much more prolific in doing that. He does it every 2 weeks, like clockwork. So there's a lot of those articles as well.
And there's also new laws new legislation coming up. It's just full of great educational information. We actually have a phone call. I think maybe
we can close it out.
I guess we don't have a phone call. I love having you guys on the show, and you make it so easy for people to understand, because the people who run for these boards have never usually have done this before.
Well, that is what we do. We make it understandable and friendly. Next month, we start the Ask the Attorneys, November 7th. We'll be talking to you again before that, so we'll remind everybody when we come back next month.
Let me tell you something. If you have a question, you'll end up with 4 or 5 questions. That's how it works.
Oh, those are great.
But people don't leave. They stay the whole time.
Oh, and then they stay afterwards and ask more questions.
No, but when we were there, was about 50 or 60 people there, and you served you had noshes there, but people were like glued to you and Michael.
Well, some of them that we do in the morning and late morning, we also will serve lunch.
So it's really important. And again, call the office, make reservations, because these do get filled up. And you know what? It's like kind of a different show when Michael's not here, because you all kind of have your own specialty that you do. He did good today, Michael. He did great today.
Oh, Michael's listening. We know.
I know he's
listening. Have a safe ride home, Michael.
Yes. So we'll be back. What's so great about this show is they're with us the first Thursday of every month from 5 to 6, so it's really easy to keep up with the show. And please continue on our Twitter. Just go to Steve O. Renee. That's all you have to do. and write us your questions. And listen, we got a lot of them on today, and we'll be doing this again every month. So if you don't get a chance to call, at least get your question in. We'll see you also next week with more Ask the Experts. Thanks so much. You drive home safe.
Yeah, thank you. See
We'll see you
month.
next week.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800